Welcome back to the deep dive.
Great to be here.
Today, we're diving into some really interesting material you've shared with us. Specifically, it's from a source called Rental Housing and Asset Management Tactics Notebook by Raymond Yang.
That's right. And it presents this real-world rental dispute. It really gets into some common, well, headaches that tenants can face.
Yeah, it sounds like a classic scenario almost.
It really is. It highlights how quickly things can, go sideways,
Yeah.
especially when what's advertised isn't quite what you find, and money changes hands before any formal contract is even signed.
Okay, so our mission today for this deep dive is to really unpack this specific situation from Raymond Yang's notebook.
Exactly. We want to understand what happened according to the source, look at the legal ideas it talks about, and importantly, figure out the practical steps someone could take based on these insights.
Right, so think of this as your quick guide to the key facts and the big takeaways from this material. Hopefully it helps you feel a bit more prepared if you ever run into something, well, similar. Okay, let's get into the case facts then, as laid out in the notebook. So it starts with someone, a friend of the reader apparently, looking for a place to rent.
Mm.
They see an ad for a unit, and it's described as 2 rooms and 1 living area. It's sounds straightforward.
A standard layout, yes. So they were interested based on that description.
Exactly. They contacted the landlord, set up a viewing. Standard stuff so far.
But then they actually saw the place. And as the material details, this is where the first big issue popped up.
Let me guess, it wasn't 2 rooms.
Bingo. Upon viewing, it was immediately clear. It wasn't 2 rooms like the ad said. It was actually just, well, 1 room. Utu.
Wow, okay. That's not a small mistake.
Yeah.
That's fundamental.
It's huge discrepancy. The source really emphasizes that point. It's a core misrepresentation of what was being offered.
So the tenant obviously points this out. What did the landlord say then, right there during the viewing? According to the notebook, anyway.
Well, the material says the landlord kind of acknowledged it, but immediately offered a fix. They said, oh, we can arrange for partitioning work to add the second room.
Okay, so trying to salvage the situation.
Right. An attempt to fix it is mentioned, but it didn't quite smooth things over.
Why not? Because then they got into the specifics of the partition.
Exactly. The tenant, reasonably enough, preferred a proper door for this new partition. Not just a curtain or something flimsy.
Makes sense. You want an actual room.
Right. And this is where the source says the terms changed again. The landlord then said, okay, if you want a regular door, that'll be an extra NT $200 per month in rent.
Wait, extra? For a door on the partition they offered to build because the ad was wrong.
Precisely. A brand new condition. Wasn't in the ad, wasn't mentioned initially when they offered the partition, just added right there.
So let me get this straight. False ad, offer to fix it, but then a charge for making the fix functional. That feels
Like you.
like moving the goalpost quite a bit.
It really does. And the source highlights this sequence. You go from expecting 2 rooms to needing a partition built to suddenly facing an extra charge just for a normal door on that partition. It completely changes the deal the tenant thought they were considering.
Okay, so things are already looking shaky. Now, the notebook mentions the tenant didn't sign the lease immediately. Why was that?
Yeah, there was an external factor.
Hmm.
A family emergency came up, apparently, which meant the tenant had to suddenly return home for a bit. So just couldn't physically sign the formal contract right then and there.
An understandable delay, sounds like. How did the landlord take that news?
Not well, according to the source. The landlord's response was reportedly quite aggressive. Accused the tenant of lacking integrity, essentially, just because the formal contract wasn't signed immediately, despite the emergency.
Wow. Okay, so that leads us to the main conflict, right? The deposit?
Exactly. The core dispute laid out in the notebook is this. The landlord refused point blank to return the deposit the tenant had already paid.
And even threatened to sue.
And threatened to sue the tenant for not signing the contract. Yes.
Oh, okay, so this whole sequence. The bad ad, the changing terms, the landlord's reaction to the delay, keeping the deposit, the threat. It's quite a situation.
It really is. The material uses it as a prime example of how a rental search can quickly turn into a serious conflict. It touches on a lot of common anxieties.
It definitely does. So, given these facts from Raymond Yang's Tactics notebook, what does the material actually say about the legal side of things? Where does the tenant stand, and what about the landlord's actions?
Right. Let's break that down, starting with that false advertisement, the 1 room versus 2 rooms issue.
Yeah, that seems like the starting point for everything.
It is. The source really stresses that rental ads aren't just, casual descriptions. Landlords have a legal responsibility for their truthfulness.
So they can't just say anything.
No. And it's not just a general idea. The notebook points to specific laws, like the
Yeah.
Rental Housing Market Development and Management Act and also the Consumer Protection Act. These hold landlords accountable.
Yeah.
And what's really interesting, according to this material, is a specific rule within the rental tenancy standard contract required and prohibited items. It explicitly says advertisement should not be merely for reference.
Ah, so the ad itself has real legal standing. It's not just for info only.
Exactly. It carries legal weight. It forms part of the basis, the understanding for any potential contract that follows.
And saying one room is two, that's not a minor detail.
Not at all. The notebook is clear. That kind of difference is fundamental. It goes right to the core of what's being offered. And if that kind of false advertising causes harm, like the tenant wasting time, paying a deposit based on false info, the landlord can be liable.
Liable for damages.
Potentially, yes. And importantly, the source knows this liability can't just be waved away in a contract clause saying ad is just for reference. The law overrides that.
So legally, the ad is treated almost like an initial promise or offer that the tenant could reasonably rely on.
That's a good way to put it. It sets the stage for the negotiation, which brings us to the deposit.
Ah, yes, the money. Always complicated.
It often is. And the tactics notebook digs into a really important distinction here, especially with the Chinese terms involved, which sound the same but mean different things legally.
Okay.
It's about dingjian versus dingyan. Notice the different first characters versus he.
Right, same pronunciation, different characters. What's the legal difference according to the source?
Okay, so here, the one with here, which often implies booking or ordering, is explained as the type of payment usually made before you sign the main contract. Think of it like earnest money or a reservation fee.
To show you're serious.
Exactly, to show seriousness and to get the landlord to hold the property while you finalize things. Given that in this case, no formal contract was signed, and key terms like the actual layout and the final rent were still being argued over.
Right, the door issue.
The material suggests this payment was most likely this ES type.
And if it is head, what happens if the deal falls through, like it did here?
Generally, the notebook states it should be returned, especially if the reason the contract didn't happen is the landlord's fault, like, the false ad and the extra charge.
Okay, that seems straightforward. What about the other one, shot?
Right. Shop, with the character implying settling or fixing. This one's different. According to the Civil Code, Article 248 specifically, receiving this type of shock actually presumes the contract has been established.
Ah, okay, so the landlord might argue it was that kind of deposit to say the deal was already locked in.
They might try. But here's another crucial point from the source. Even if, for the sake of argument, it was considered this set under Article 248, the tenant still has strong rights
Oh, how so?
because of the next article, Civil Code Article 249. Section 3 is key here.
Okay, what does 249 say?
It says that if the contract can't be fulfilled for reasons attributable to the party who received the deposit, so the landlord in this situation, then the landlord must return that deposit.
Must return it.
Yes. And get this, the source highlights that Article 249 actually says they might have to return it doubled.
Doubled? Really?
That's what the code allows for, apparently. It adds significant leverage for the tenant.
Definitely. And in this case, the reasons the contract failed.
Seem clearly attributable to the landlord, right? The source points directly to the false advertising about the rooms, and then the demand for extra money to fix their own misrepresentation. These actions directly prevented the contract from forming based on the original truthful understanding the tenant expected.
So bottom line on the deposit, according to this notebook, whether it was technically yay or sent, the analysis strongly suggests the tenant should get it back because the whole mess was the landlord's fault.
That's the really powerful conclusion from the source regarding the deposit. Yeah.
Are there other protections discussed in the material that are relevant here?
Yes, absolutely. There's the mandatory contract review period.
Ah, the cooling off period.
Sort of. For standard residential leases in Taiwan, there's a minimum 3-day review period required before signing. It's a key tenant protection.
And the purpose is just to give people time to read it properly.
Exactly. Time to read, understand fully, maybe get advice, all without feeling pressured to sign on the spot. And this source emphasizes this right cannot be waived. You can't sign it away.
How does that apply here, though, since they never even got to signing a contract?
Well, the point the material makes is this. If the tenant found out about the big problems, the one-room reality, the extra charge during that potential review period, maybe they got a draft or these issues came up as they were discussing terms within that time frame, and then decided not to sign because of those issues.
They were just exercising their right.
Precisely. They were using a legally protected period to evaluate the actual deal, which turned out to be different and worse than advertised. The landlord can't legally punish them for using that right by keeping the deposit.
So taking the deposit before even providing the contract draft for review might be problematic itself.
The material definitely implies that. It could be seen as undermining the whole point of the review period, putting pressure on the tenant before they've had a fair chance to review.
It really sounds like the landlord was trying to lock the tenant in based on false information, then change the rules.
That's very much the picture painted in the notebook.
Yeah.
That demand for extra payment is framed as the landlord unilaterally changing terms after getting the tenant interested and taking their money, based on a misleading ad.
And the tenant doesn't have to accept those new terms.
Absolutely not. They aren't legally obligated to agree to new, less favorable conditions sprung on them like that.
And putting the false ad together with the demand for more money, it starts to look like, well, bad faith, doesn't it?
It does. And that leads directly to another legal concept the source brings up: pre-contractual negligence.
Pre-contractual negligence.
Okay.
What's that about?
In Chinese, it's e-com, covered by Civil Code Article 245-1. The core idea is that even if a formal contract never actually gets finalized, the parties involved in negotiating it still have a duty to act honestly and in good faith towards each other during the negotiation process.
So you have responsibilities even before the contract is signed. You can't just mislead people during the talks.
Correct. You can't act negligently or dishonestly in a way that harms the other party while you're trying to make the deal.
And how does the notebook apply that here?
It argues pretty strongly that the landlord's actions squarely fit this. Knowingly publishing a false ad about a key feature like the number of rooms, and then demanding extra payment to fix your own misrepresentation. These are presented as clear violations of that duty of good faith during the negotiation phase.
And the connection to the tenant's deposit.
The source explains the deposit represents a tangible loss the tenant suffered because they trusted the landlord's initial false information. They entered negotiations and paid money based on that trust. So, under this principle of pre-contractual negligence, the tenant can claim that lost the deposit back from the landlord. Why? Because the landlord's negligent or dishonest behavior during the negotiation caused the loss and prevented a fair contract from ever forming.
Wow, so that's another strong legal angle for the tenant to get their money back, specifically targeting the landlord's behavior before any contract was signed.
Exactly. It reinforces that you can't just act however you want before the ink is dry if your actions harm someone relying on your good faith.
Okay, this is fascinating. The legal analysis from Raymond Yang's notebook seems overwhelmingly stacked in the tenant's favor here. The landlord's case looks pretty weak.
Based on the facts presented, yes.
But as we know, knowing your rights is one thing, actually doing something about it is another. So how does the tactics notebook advise someone in this situation to proceed? What are the practical steps?
Right, the practical side. The material really emphasizes formal communication as the crucial first step. The number one action recommended is sending a formal written notice, and specifically using a certified letter. In Chinese, that's a certified letter. Why is that specific format so important?
It's all about proof. It creates an official, undeniable record. You have proof that you sent a specific document with specific content on a specific date, and crucially proof that the landlord received it. It's rock-solid evidence if things escalate.
Okay, makes sense. What should go in that letter, according to the notebook's advice?
The source suggests a clear structure. First, lay out the basic facts. Your name, the landlord's name, the property address, when you viewed it, when the deposit was paid, the exact amount. Be precise.
Get the details down.
Absolutely. Then, state the core problems clearly. Describe the false advertising, explicitly mention the one-room versus two-rooms issue, describe the landlord's offer to partition, and then the demand for extra money for a proper door. If you have screenshots of the ad, mention that you have this evidence. And you also need to explain why you didn't sign the contract, right?
Yes, very important. State clearly that the reason you didn't proceed was because of the landlord's actions, the initial false ad, and the subsequent changing of terms with the extra cost. Explain that this fundamentally altered the deal you thought you were making.
Okay. Then the demand.
Make a clear, unambiguous demand. Request the full amount of the deposit back. Specify a reasonable deadline for the return, like, say, 7 to 14 days from their receipt of the letter.
Should you mention the legal stuff we just talked about?
The notebook suggests it's a good idea to briefly reference the legal basis. It shows you've done your homework and understand your position. You could mention things like the contract failing due to the landlord's fault, citing the false change terms. Maybe reference the Rental Act or Consumer Protection Act regarding false advertising. And definitely mention the landlord's pre-contractual negligence under Civil Code 245-1. You could also mention the review period issue.
Just enough to show you know your rights.
Exactly. And finally, the letter should include a clear statement about next steps.
Like a warning.
Pretty much. State clearly that if the deposit isn't returned by your deadline, you'll be forced to pursue further action. You can mention options like filing official complaints, seeking mediation, or initiating legal proceeding.
And keep copies.
Absolutely critical. Keep copies of the letter itself, and especially the post office receipt proving it was sent certified and when. That's your proof.
What other evidence should someone be gathering alongside sending the letter?
The material lists the key things. Definitely get a copy of that original advertisement. Screenshots are perfect. Keep every record of communication. Texts, emails, chat logs, anything exchanged with the landlord. Get solid proof of the deposit payment, the receipt, bank transfer confirmation, whatever you have.
Document everything.
And the source also suggests keeping a simple personal log, dates, times, and brief notes on any verbal conversations you had. Just build that clear trail of evidence.
Okay. So you send this certified letter, you've got your evidence compiled. What happens if the landlord still refuses to budge? What are the next steps? The dispute resolution path the notebook talks about.
Right, if the letter doesn't work. The material outlines a few options. First, check with your local government. Many city or district offices offer mediation or negotiation services specifically for rental disputes.
Is that usually effective?
It can be. It's often faster, less formal, and cheaper than going straight to court. Definitely worth exploring.
What about consumer protection? You mentioned the Act earlier.
Yes, that's another key avenue.
Yeah.
Because the Rental Act frames the landlord-tenant relationship as a consumer one, you can file a formal complaint with your local consumer protection officer. They have the authority to step in and mediate the dispute.
Does the landlord need to be a big company for that?
The material suggests that for rental issues under the Act, this protection generally applies even to individual landlords. Other possibilities mentioned in the source include, potentially, the Fair Trade Commission, especially if the landlord rents out multiple properties and this false advertising seems like a regular business practice. And of course, seeking advice is always smart. Look for legal aid services or find a lawyer who specializes in rental law, especially if the deposit amount is large or things feel complicated.
Yeah.
Many offer initial consultations for free or low cost.
And then there's court, I suppose. The landlord in the story threatened to sue the tenant.
Court is definitely an option, though often seen as a later step if other methods fail. For smaller amounts, the source mentions typically under NT $100,000 in Taiwan, small claims court is designed to be a simpler, more accessible process.
So the general strategy is letter first, then mediation or consumer protection, then maybe court.
That seems to be the logical progression suggested in the notebook, yeah.
Yeah.
Start formal, but aim for resolution, escalate if necessary.
Let's circle back to that landlord's threat to sue the tenant. Based on everything we've discussed from the notebook, how should someone actually react if they get threatened like that?
I think the main message from the material is don't panic and don't be easily intimidated.
Easier said than done, maybe.
True, but understanding your position helps. The landlord's likely argument, if they did sue, would be something like, you agreed to rent, you paid a deposit, you didn't sign the contract, so you breached the agreement and I keep the money.
But based on the source's analysis, the tenant has a whole arsenal of counterarguments, right?
Exactly. Your defense, drawing directly from the principles in the notebook, would be, no, a valid contract didn't form fairly because of the landlord's actions. Point to the false advertising, point to the change terms and extra costs. Argue that the payment was likely, earnest money, that must be returned when the deal fails due to the landlord's fault. Or, even if they claim it was sin, argue that Civil Code 249 requires its return, maybe even doubled, because the failure was attributable to the landlord.
Plus the review period argument.
Right. Mention you were within your rights during the review period. And crucially, bring up the landlord's pre-contractual negligence. They acted in bad faith during negotiations by misleading you.
So putting it all together, the source seems to conclude that the landlord's legal grounds for keeping the deposit and suing the tenant are actually quite weak in this scenario.
That's the strong implication, yes. The threat is more likely posturing, an attempt to scare the tenant into dropping the issue. Knowing the points we've discussed from this material gives you the confidence to stand firm and follow the recommended steps.
This has been a really insightful deep dive into Raymond Yang's Rental Housing and Asset Management Tactics Notebook. It really demonstrates that tenants facing these kinds of issues, false advertising, deposit disputes, actually have significant legal protections, especially under Taiwanese law like the Civil Code, the Consumer Protection Act, and the Rental Act.
Yeah, the key takeaways are pretty clear, aren't they? Document everything meticulously. Understand that crucial difference between yen and yang, and why, in a case like this, the landlord's fault likely means the tenant gets the money back either way. Know about your non-negotiable right to a contract review period.
And remember that bad faith behavior before a contract is signed, that pre-contractual negligence has real legal consequences.
Absolutely.
And the actionable advice from the notebook is practical too. Don't let threats scare you. Be proactive. Start with that formal certified letter, have your evidence ready, and use the dispute resolution channels like mediation or consumer protection if you need to.
It really provides a solid roadmap based on legal principles.
Thinking about this whole case, especially how it started with an online ad, it does make you wonder, doesn't it? How much responsibility should the websites or platforms that host these rental ads take? Should they be doing more to check if the ads are actually accurate before tenants even waste their time viewing or paying deposits?
That's a really interesting question. Adds another whole layer to think about in the rental ecosystem, doesn't it? Potential platform accountability.
It certainly does. Well, if you found this deep dive useful, if it maybe clarified some things about handling rental problems, you can find more analysis like this right here where you get your deep dives.
Yeah, and we genuinely love to hear your thoughts on this case or the legal points we covered. Please do consider leaving a comment below. Let us know what you think.
Absolutely. And if you want to catch our next deep dive into valuable material, maybe even more from Raymond Yang's notebook or similar sources, make sure you subscribe so you don't miss out.